All right. Hello, everybody, and welcome to another edition of Question Immigration, presenting this time regarding what we commonly call the fastest way to get permanent residency, the employer-nominated visa subclass 186 in the direct entry stream. And today we'll be presenting the essential insights on the visa application process. We'll also be covering skills assessment information and answering some of your burning questions that you have provided us. All right, so we'll just get through today's agenda. So today's webinar agenda will consist of introduction to the Employer Nomination Scheme 186 Direct Entry Visa. We'll also look at the eligibility criteria, obviously some of your frequently asked questions. From our perspective, the do's and don'ts. Obviously, we've got a lot of experience successfully handling this visa subclass, both from the employer side and from a candidate side as well. We'll look at what the requirements are if you intend to include family members, so the family requirements, and then we'll conclude the webinar with some of the amazing questions that you, the audience, has posted today. All right, so general information about the employer nominated visa subclass 186 entry. So basically, the focus is on answering your questions. Through this webinar, we also aim to provide essential information and empower you, I guess, with the knowledge about this visa subclass, and also answer any participants' questions regarding the visa process. And we do have many amazing questions that you've posted. All right, so regarding eligibility, basically, obviously, this visa does require employer nomination. So the employer requirements predominantly centre upon the legal operation of the business. So employers must be legally operating a registered business in Australia to qualify for eligibility. Obviously, there must be a genuine need for a full-time position. So the position must be within the scope of the business activities, and also the salary must be in line with Australian market salary rates. So employers must comply with the market salary rate and the CSIT, which is replaced the TISMA, which was the income threshold. And just for your information, we've had some news this morning about the CSIT, the core skill income threshold, and the current salary required or requirement is 73,150, and from effective July 1 in this year, the new CSIT will be 75,500 odd. So, and that will increase every year in line with CPI or inflation. So that will continue to rise on an annual basis. Now, in terms of the visa applicant, obviously applicants must ensure their occupation is listed on the core skills occupation list. And the good news is that since December 7 and the introduction of the core skills occupation list, there are actually 458 occupations that you can avail. And we'll just have a look at some of those, right? So as you can see here, it is quite an expansive list, and it has a whole range of occupations. So previously, the applicable list for the 186 was a medium-term list, but now there's a sort of conglomeration of the medium-term list, short-term list, and also the regional occupation list. So there has been an expanded list, Some occupations have been omitted, like graphic designer, disability services officer, also cafe and restaurant manager. However, others have been included, and they include occupations like childcare worker, and there's a number of questions relating to that occupation, which I'll answer later. Also, office manager, and a whole range of other occupations. So it's been a welcome list, this CSOL, and it really gives as many people as possible the opportunity to apply for the 186 visa. Moreover, so you do need to have a valid skills assessment in your nominated occupation. So if you're applying, for example, as a chef or a trade occupation, typically you'd need to have a positive assessment from the TRA, the Trades Recognition Authority. If it's a general occupation, like a HR advisor or a landscape architect, then typically you would need to get a skills assessment from VetAssess. If you're an engineer, it would need to be from Engineers Australia. If you're an accountant, from CPA, and so forth. If you're a teacher, from the AITSL. So depending on your occupation will dictate which is the relevant skilling assessing authority. And skilling assessing authorities usually have their own requirements. So, for example, VetAssess for a general occupation, you'd have to have a relevant qualification at the right skill level, and you'd also have to have 1 year post-qualification work experience. There are some concessions to the work experience, to the qualification. If you don't have a relevant qualification at the right skill level and you've got a diploma or an advanced diploma, for example, then you can still get a positive assessment, but you might need to have 2 years as opposed to 1 year work experience. So depending on the assessing authority, whether it's ACS, the Australian Computer Society for Information Communication Technology, Occupations, Engineers Australia for engineers, will also dictate what the requirements are. For example, engineers, typically if you've got a qualification from a non-accord country, and that also incorporates many South American countries, then you will need to do a competency demonstration report. You don't necessarily need to have a work experience, but you will need to demonstrate your competency through career episodes. Those career episodes can be based on also practicums, assignments, and project work during your university. Some assessment authorities require an English requirement, some don't. So you need to just pay particular attention to that. Applicants must also be able to demonstrate at least 3 years of skilled employment in their nominated occupation to satisfy the reso requirements. So in essence, the key word here is skilled employment. So what typically is regarded skilled employment is post-relevant qualification. So depending on the ANSCO skill level, 1 to 4, will also depend on what level of qualification you require. So engineers, for example, they'll mostly be skill level 1 occupations. So the relevant occupation would be a bachelor degree. Once you've completed your bachelor degree and you're working in a role that aligns with your nominated occupation from a task perspective, and you've done so for 3 years, and that's paid employment, full-time or part-time equivalent, prorated. It can also include contract work. However, you just need to be working at least 38 hours, and you would need to also verify that work experience, not only with reference letters, but also with pay evidence, so 2 forms of pay evidence. So that one could be your pension documents, pay slips, and also bank accounts. If you've been working as a contractor, then you would also need to present invoices, bank statements, and income statements from the government. So provided you can satisfy the 3-year skilled employment requirement and also have a valid skills assessment from the relevant assessing authority, then you will be able to satisfy the work experience requirement. Another critical requirement of the 186 visa is English language proficiency. So you must prove competent English skills, and typically with IELTS, this would mean a score of 6 in each band, and in PTE, for example, it would be a score of 50 in each band. Now, the tests need to be within the last 3 years, right? And we'll look at, next slides whether there are also any exemptions to that. Now, you can include your family members, right? Obviously, de facto partners or spousal partners, married partners. So de facto relationship means that a couple lives together on a genuine, or they're married, they're not living permanently apart. So for de facto purposes, you will need to demonstrate that you have lived or cohabited together for at least 12 months, unless you can provide a registered relationship certificate. Moreover, we would need to also provide a portfolio of partnership evidence, and that would need to demonstrate that you satisfy the 4 pillars of a partnership, and that's the financial aspects, social aspects, also genuine commitment, and household arrangements. So if you've got a registered relationship certificate, that would alleviate the 12-month rule. So even if you've been living together, you've got joint financials, joint socials, joint household arrangements, and genuine commitment for at least 6 months, then that would suffice. In terms of partners who are over 18 years old, they do need to also provide an IELTS or PTE equivalent score. So the score required is functional English. That test needs to be within the last 12 months, and the score for functional English is 4.5 band overall. There are some exemptions available for partners, not so with primary applicants, unless you've got a passport from US, UK, New Zealand, South Africa, etc. So we will have a look at these exemptions in the later slides. Some of the recommendations that we have, and like I've said earlier, we've successfully processed hundreds of 186 visas from a nomination, company nomination perspective, and from a visa application perspective. So you do need to ensure that you accurately calculate your skilled employment to meet eligibility criteria. And one of the practices that we employ within our agency, we've developed calculators specifically for this purpose. And unless we're categorically certain that someone fulfills the skilled employment requirement, obviously we won't lodge the visa, because as a matter of fact, all with this ENS 186 visa, it's a time of application criteria, the skilled employment. So at the time you lodge your visa application, you need to ensure that you've calculated correctly your skilled employment, and that equates to at least 3 years full-time or part-time equivalent skilled employment. We also encourage your employer to schedule a free consultation with us. I mean, once we've established your eligibility, we do obviously send you a summary, and we also, if you're not eligible, we'll let you know what you need to do to become eligible. But if you are eligible, we'll obviously send you an estimate of fees, we'll confirm your eligibility, and then we'll also send you a link where we invite your employer for a complimentary meeting to discuss the overview of the requirements, the costs, and also the process. And believe you me, I mean, if I have the chance to speak to your employer, 9 times out of 10, I can convince them that this would be the best pathway and secure your process. What you should also keep in mind is that you should maintain your current position while your application is processed. So it's important to obviously undertake your work in a manner which doesn't sort of get you offside with your employer, because at any stage they can withdraw the application. Obviously, they need to follow HR practices and abide with fair work rules, but it is possible. So at any point in time, I mean, they are, because this is a nominated visa, you do need the support of your employer, and that support should be consistent all the way until the visa is granted. We will talk about the conditions of the grant, and we'll look at that in some of the later slides. Some of the stuff that you should also be aware of, and we would like to bring to your attention that you should really consider this as the don'ts in this situation. So always ensure that you're using the correct ANSCO code to avoid unnecessary errors and complications. And on this point, I mean, with the 482 visa for the skill in demand visa, for example, you are able to work in your nominated occupation or a closely related one. And what usually depicts or describes closely related is that the first four digits in your ANSCO code are the same. But this flexibility is not afforded to the 186. You really, if you've got a skills assessment in your nominated occupation, then you should be nominated, or you must be nominated for exactly the same ANSCO code for the purpose of this visa. Now, obviously, with your tasks, 70% of the tasks should at least align with the ANSCO tasks. Sometimes we can get a little bit creative with the job title, but in essence, it needs to relate directly with the ANSCO code that you have a skills assessment with, your skilled employment is with, and it should be the same occupation you're nominated for, and that should be the occupation that you will work for during the visa. Now, you also need to verify that the position is genuine. It's a genuine position within the business and fits within the scope of the business activities. Genuine needs submission is probably one of the most important aspects of the company nomination, and that requires a detailed submission. And obviously, as us as the migration agents, we need to understand the intricacies of the business and also of the role. And based on your position description and information we gather about your business, we're able to satisfy this requirement. We typically prepare the genuine needs submissions on behalf of your business. We can source a lot of information from the internet, from also remuneration surveys, also from the position description. We usually send that to your employer to review. They can make some tweaks, or if they're not happy with something, they can advise us to change this or that. Once we're happy with the document, we again send it to your employer for sign-off, and then we include it in the nomination application. You also got to be mindful of your skills assessment, and it hasn't expired. So typically, a skills assessment for the purpose of the 186 visa is valid for 3 years. This is unless there's a date specified on your skills assessment outcome letter. So if it's specified for 2 years, then the validity of your skills assessment will be for 2 years. If there's no date on your skills assessment outcome letter, then it's taken that it's valid for 3 years. Now, you just got to be mindful of that and be careful. So the skills assessment requirement is also a time of application. So you need to have a valid skills assessment at the time you apply. This is different again from the 482 skill in demand visa. there are some occupations that do require a skills assessment. Either there's a caveat, or if you've got a passport from a particular country, as also in relation to certain occupations, you do need a skills assessment for the skill in demand visa, but it's a time of decision requirement. So as long as you've applied for your skills assessment, then you're able to lodge the visa. As opposed to the 186 visa, today's topic, you need to have your outcome letter before you apply for the 186 visa. So that's very important. If you're mindful of that, it shouldn't really trip you up, but it is something important to know. Now, do not leave it too late to act on important business decisions to ensure success. So, I mean, you should have that conversation with your employer as early as possible. What my recommendation would be is that get some professional advice, confirm your eligibility, understand what the requirements are, understand if you're not eligible, what you need to do to become eligible from a timeline perspective. Once you've got all that information and you're empowered with all that detail, then you can have a conversation with your employer, right? Because if you're going to your employer and you're not sure and you're umming and ahhing, it's not going to be a good look. However, if you've got all the facts before you and up front, you can go and have that conversation with your employer with a lot more conviction. And if it's we've confirmed your eligibility, they'll also have the opportunity to book a complimentary meeting for us to go into bat for you as well. Now, obviously, we're representing the candidate and the employer. I mean, so when we say we're going to bat, we're just really going to explain to them the benefits of the program and so forth. We also need to explain to them that, it is a permanent residency visa, and once the visa is approved, obviously the applicant becomes a free agent. Most employers understand that anyway. That's why sometimes they prefer the skill in demand visa over the 186 visa, because it gives them a little bit of safety net in terms of the employee leaving straight after the grant. But it all depends on your relationship with your employment, the trust factor. So every situation is different. But I mean, if you're eligible for the 186 visa, then certainly that should be the visa you should be gunning for. I mean, and then as a backup plan, obviously you can also apply for the skill in demand visa. Now, not to be sort of mistaken with the direct entry scheme, if you do apply for the skill in demand visa at any time, and that's approved, at any time, if you've got a valid skills assessment and you can demonstrate that you've got 3 years of skilled employment, you can apply for the direct entry visa if your sponsor or any other employer for that matter is prepared to support you with that application. In any case, after you work for 2 years for your sponsor or any sponsor for that matter on a skill in demand visa, you can be nominated for permanent residency through the 186 in a different stream, which is the transitional temporary residence or TRT stream, right? So all is not lost. Now, some of the frequently asked questions that we receive from our clients. So can I be nominated for a remote role? Well, I mean, that's a bit of a tricky one, but the answer, our office, official sort of response from our office is no, you can't, because, and I explained to you why. I mean, it really defeats the purpose of the 186 visa or any visa for that matter. I mean, if you can do the job remotely, then why do you need to be in Australia to do that job? You can be anywhere in the world. So we believe that it should be an office position, or you should be in the state that you're being sponsored by. I mean, in some circumstances, if it's a multinational company that's got offices throughout Australia. It can be a somewhat remote role potentially, but in most circumstances, a remote role would not be appropriate for the 186 visa. Do I have to stay, excuse me, in the same position for 2 years after the visa grant? Well, the reality is that once your 186 visa is approved, you are a free agent. Now, in saying that, when you apply for the 186 visa, you do make a commitment to work for your employer for the next 2 years, as does your employer. They make a commitment to employ you for the next 2 years. But the reality of the situation is, and the nature of a permanent visa, is that once you're granted permanent residency, that commitment is not worth the paper that it's written on. And I mean, you could tender your resignation the next day. I mean, and also if your employer followed their HR practices and fair work standards, they could make the position redundant all the same, right? So, I mean, this is a bit of a double-edged sword because a lot of employers are obviously familiar with this, and that's why sometimes they're a little bit reluctant to nominate someone for the 186 visa if they can nominate them for the skill in demand visa instead. So it's a bit of a juggling act, but I mean, it just depends on the employer-employer relationship. But yeah, to answer the question, you're not required by law. And even if you did tender your resignation the next day, I mean, there aren't any ramifications or implications to your visa status, and there wouldn't be also any ramifications or implications to your citizenship application sometime down the line. How long is my skills assessment valid for the 186 direct entry applications? As we said earlier, typically this would be for 3 years, unless there's a specified date on your outcome letter. So if your outcome letter says for 2 years, then your skills assessment will be valid for 2 years. If your outcome letter from the Skilling Assessing Authority says 1 year, then your skills assessment would be valid for 1 year. If your skills assessment outcome letter doesn't have a date, then it's valid for 3 years. Okay. Now, are there any English exemptions for primary and secondary dependents? Apart from passport holders of the US, UK, also New Zealand, Republic of Ireland, and US, as we said, there aren't any exemptions for primary applicants, right? However, so you will need to produce, if you're not a passport holder from those countries that I just mentioned, you will need to produce or present English test report within the last 3 years. If it's IELTS, it needs to have a band score of at least 6 in each band. And if it's PTE, you'll need to have a band score of at least 50 in each band. And as I said, that test must be within the last 3 years, unless you're a passport holder of the countries I mentioned. Regarding partners or dependents, the score that you need is 4.5 overall, which is what we typically call functional English. If you're presenting a test, then that needs to be within the last 12 months, right? Otherwise, there are exemptions for functional English. That is that you've studied at least 1 year in Australia, either diploma, advanced diploma, associate degree, bachelor or master's. And if you've studied 1 year in Australia, then you'll be exempted. Otherwise, you could have studied for at least, I believe it is primary or secondary education overseas. So the applicant would need to provide evidence of having completed all years of primary education and at least 3 years of secondary education at institutions overseas where the language of instruction is in English. So there are those exemptions available for secondary or dependent applicants who need to demonstrate functional English. Now, and I mean, for that case, I mean, we typically get a lot of clients from the Philippines who have studied, primary or secondary school, and the language of instruction is in English, and some other countries, more recently Indonesia and so forth. But even if your partner has been in Australia on a student visa and they've done a 1-year diploma, then they'll be exempt from the functional English requirement. Now, in terms of processing times, this is where sort of the bad news starts. So at the moment, and I can demonstrate this as well. So at the moment, we're looking at processing times. 50% of applications are processed within 13 months. However, 90% are processed within 18 months. So we are having some earlier grants, but that's typically for occupations in priority sectors like health, teaching, and so forth. But we have, some engineers, chefs, also other occupations that we've been waiting an awful long time. And basically, we can provide this thing for you later, but I've put into this search function from Home Affairs, so Employer Nomination Scheme, Subclass 186, Direct Entry Pathway, and say we lodged the visa today, the 26th of March, 2025, then this is the standard processing time. Now, what this means also is that there's a big range here, but in essence, if we've got applications that are pending and they're within this green area, then we can't raise a complaint. I mean, if we do raise a complaint, the case officer or the team at Home Affairs will just send us a generic response, and they will say that the application is still within the published Department of Home Affairs publishing times. We can't do anything about it. Come back to us once you're in the orange area. So as easy as that. So so that's the processing times. Now, another common question we get is, do I get a bridging visa after submitting the 186 direct entry visa application? And the answer is yes. I mean, as long as you've lodged your application onshore or in Australia, whilst holding a substantive visa, then you will get automatically a bridging visa A associated with your 186 direct entry visa application. That bridging visa A will allow you to remain in Australia lawfully with work rights until your visa is approved. Now, the other thing to probably mention is we've got a lot of review applicants at the moment that have come to us from education agencies after their student visa has been refused. And this is a common scenario, unfortunately, these days, as the Department of Home Affairs continues their crunch on the student visa program. And typically, these applicants would be on a bridging visa A because they would have lodged their student visa many months ago. So their last substantive visa would have expired. However, they're on a bridging visa A associated with their student visa application. Then they receive a refusal, right? So they lodge an appeal, and basically the bridging visa A continues indefinitely until their appeals process concludes. We have lodged 186 direct entry visas for applicants in this scenario, and skill in demand visa visas as well. We do need to manage bridging visa situations. So typically what we would do with this type of client is we'd organise all the paperwork for the company nomination, lodge the nomination, then we'd prepare simultaneously the visa application. We'd arrange a bridging visa B for the clients who they use a travel facility. Because they've got a refusal and they're on a bridging visa, they're what's called Section 48 barred, so they can't lodge a visa within Australia. But if we secure them a bridging visa B, which is a travel facility, they travel overseas, we lodge the visa, then they're allowed to return to Australia because their bridging visa B is a travel facility, so there's no risk associated with that. Once they're on shore, we apply for a new bridging visa to link to the offshore 186 visa, and then basically we withdraw the appeal, and then they're onshore waiting for their 186 direct entry visa to be approved. So it's a little bit tricky. I mean, we're in this, we're managing bridging visa situations on a daily basis, but I mean, there are ways, obviously, whatever your situation is, to overcome any sort of hurdle or challenge, right? So on top of that, I mean, we also have a really good question about what is skilled employment and how do I calculate my skilled employment period. Yeah, again, I mean, I think we touched on this earlier, but skilled employment in regards to the 186 visa means that it's employment post the relevant qualification. So if you're a civil engineer, then you'd have a bachelor degree in civil engineering, maybe 4 or 5 year duration. You can't include the practicum that would have been incorporated in your bachelor degree. Once you've completed your bachelor, then you can start counting skilled employment, as long as your employment is at the appropriate skill level. And how do we prove skilled employment? We prove it with reference letters, and your tasks should align at least 70% with the ANSCO tasks. You must have the relevant qualification. So if it's skill level 1, you'd need a bachelor degree. If it's skill level 2, you'd need a diploma or advanced diploma. If it's skill level 3, you would need a certificate 4. If it's skill level 4, you would need a certificate 3. So once you've got that relevant qualification and you're working in a occupation at the appropriate skill level, you can start counting your skilled employment. It needs to be 3 years, so it would need to be 3 years full-time or part-time equivalent. So if you've been on a student visa for 6 years working in your nominated occupation, then that would count as 3 years full-time, right? So, and as I said earlier, you can also count casual or contract work, but you need to be working at least 38 hours per week to count the relevant periods. Do I need to be paid the nominated salary at the time of nomination application? Not necessarily. So what we, I mean, and there's a number of reasons why you can't be paid the nominated salary. You might be on a student visa, for example. So if you're on a student visa, then obviously you're working maximum 24 hours a week. So it would be unreasonable, or you couldn't possibly earn a full-time salary with 24 hours a week. So what we typically do in that situation, we submit obviously a full-time contract as part of the nomination application, but we do have a clause there that the contract is subject to visa approval, and once the visa is approved, you'll be paid the nominated salary. But even if you've got full work rights, you're on a graduate visa, and you're not being paid the nominated salary at any given time, you can continue to be paid any salary until your visa is approved. However, once your visa is approved, you need to be paid, obviously, the nominated salary. What if my occupation is taken off the list during processing. I mean, so look, typically, I mean, if you've already lodged your visa and then the occupation is taken off the list, that wouldn't impact your application. So there's no worries there. I mean, I don't think that's so much of a concern at the moment, because recently we've had the implementation of the CSOL. However, you know, there would have been some people potentially who this was to their detriment in December, if they hadn't already applied for their 186 visa and they were planning to, and then the occupation was taken off the list, then obviously that's some really rotten luck. But if you have lodged your visa and then it's taken off the list, there wouldn't be any issues there. Now, that sort of concludes today's presentation. We do have some questions, additional questions from the audience. So, Shini, if you just want to read out those questions, and I'll see how I can answer them best.
Yep. Thanks, Bill. Informative session, and I'll just get started with the first question from Donna. If under 482 visa with permanent part-time contract but working 38 hours per week, am I still eligible for visa 186, and how many years experience is needed for this visa?
Yeah, okay. Well, I think I think, what was the person's name? Sorry, Shini?
Donna.
Donna. I think Donna might be referring to the TRT stream there, because if she's on a 482 visa, if she works for her employer for at least 2 years on a skill in demand or temporary skill shortage visa, depending on when she applied, then she'll be able to transition to permanent residency through the TRT stream. And that would be just based on her payroll information. So provided that she's been paid her nominated salary for at least 2 years, then her employer could nominate her for the 186 visa in the TRT stream. Alternatively, if she wanted to apply for the 186 visa in the direct entry stream, and provided that she fulfills the skilled employment requirement, has a valid skills assessment, and competent English, then and her employer is prepared to nominate her for the 186 direct entry stream, then they can do so at any time.
Right. Thank you for that. I'll move on with the next question. So this is from Diana. They've asked, I currently work in childcare and have completed my skills assessment in Queensland. For applying for a regional visa, DAMA, do I need to undergo a new skills assessment for New South Wales in order to apply for the 186?
Yeah, this is a really good question, Donna, and it's interesting because it's pretty timely, because we've got a number of clients in a similar situation, and we've actually been in discussion with ASEQA, who's the assessing authority, and you're quite right in pointing out that childcare worker is now on the CSOL, and by virtue of that, it's eligible for the 186 visa in the direct entry stream. But we have had some complications with ASEQA, because even though childcare worker is on the CSOL, ASEQA hasn't actually got a skills assessment available at the moment for childcare worker. So it's a bit of an oxymoron. It is an eligible occupation, but there's no way to get a skills assessment at the moment. And actually, we had some emails correspondence from ASEQA today, and they are aware of this issue. and they are in discussions with the government to fix this problem or address this problem. But they couldn't give us any timeline specific. And basically, they said at this stage, we just need to monitor their website, and when this occupation childcare worker is available for a skills assessment, they will publish it on their website. Now, it doesn't help you or me or our clients, but yeah, the reality is until there's an available skills assessment for childcare worker, then you won't be able to apply for a 186 direct entry visa. Now, the other thing you've got to be aware of is, I mean, with DAMA in Queensland, you may have a salary concession with the DAMA. So instead of having a minimum salary of 73,150, potentially you could have a salary of 65,000 odd thousand. This won't be available with the 186 direct entry visa. So if at some stage a SECLA do make a skills assessment for childcare worker, full skills assessment available, whenever that happens, and you find an employer in metropolitan Sydney, Melbourne or Brisbane, and they're prepared to give you a full-time contract of 73,150. If that time is after July 1, 75,500, then potentially you can apply for the 186 direct entry visa in a metropolitan city like Sydney, Melbourne or Brisbane.
Thank you, Bill. I'll move on to the next question from Cherise. I'm 34 years old, graduating from nursing this first semester of 2025. I've been working as a nurse in the Philippines for around 9 years. What are my options? I have a de facto partner.
Yeah, okay. I mean, so obviously she's has worked as a nurse, or Cherise worked as a nurse in the Philippines. I imagine she's probably got a 4 or 5 year bachelor degree from the Philippines. I mean, if she's able to get a skills assessment as a nurse in Australia, and I understand that she's finishing her qualification in nursing. I don't know whether that's a diploma of nursing, which would be an enrolled nurse, or a bachelor of nursing, or a master's, which would make her eligible for a registered nurse. But yeah, if she's able to undergo skills assessment through ANMAC, and she's got an Australian qualification, so it shouldn't be that difficult to get the skills assessment after she gets her Australian qualification, and she's got 3 years work experience as a registered nurse, albeit in the Philippines. Then she could be eligible for either the Skill in Demand 482 visa or the 186 direct entry visa. I mean, but even skilled migration, I mean, she could do it independently. I mean, nurses are getting invited on 65 points. So if she's doing a bachelor degree, how old did you say she was, Shini?
34.
Okay, I mean, the best option I would say would be to, provided she can apply for a graduate visa before she turns 35, is apply for a temporary graduate visa. It should be for a duration of 2 years, get her skills assessment, and then she can launch an expression of interest, also registration of interest, depending on which state she's in at the moment. And she's more than likely to receive I'd imagine her English is at a really high level, because to study nursing, you need to have really good level of English, solid. So, I mean, she could receive an invitation for a skilled visa, either 190 or 189, or if she's in the regional area, 491. So there's plenty of options there for Cherise.
Right. Thank you, Bill. Moving on to the next question from Carmina. Can a childcare worker with 4 years experience and currently under the 482 labor stream visa, can I apply to another employer and directly do the 186 visa?
Yeah, I think this is the same as the previous question. So yeah, I mean, the issue is that the Skilling Assessing Authority, SEQA, don't have any skills assessment at the moment available for childcare workers. So it's not possible right now. We have had correspondence with SEQA as recently as today that they're aware of the issue and they're working with the department to solve it. They haven't given us a time frame, but unless she can get a valid full skills assessment as a childcare worker, then she won't be able to access the 186 visa in that occupation. It will be sorted, but I mean, it's a matter of time. Right at this moment, no, but once a SEQA is able to assess skills assessments for childcare workers, and provided childcare worker is still on the CSOL list, then it won't be a problem in the short-term future.
Right. Thank you, Bill. I'll move on to the next question from Denise. I saw graphic designers not in the list anymore. What are the options for people who are in this profession?
Yeah, I mean, that's one of the fortunate occupations. So, look, you can still, I guess, apply for a training visa if you find if you're employed and they're willing to nominate you as a trainee. A training visa would certainly be one option because it's still on the relevant list for a training visa. Obviously, if you can get a skills assessment, you can still be in consideration for a skilled visa. So either the 190 state nominated or 491. Obviously, you'd have to be in a state where it's an eligible occupation. We can have a bit of a look at that. So let's have a look. So if we look at graphic designer, and you can all access this tool on our website, guys. So if we look at graphic designer, I mean, it's still eligible for the 407 training visa. It's not actually eligible for the 482, but it is also eligible in certain states for the 190 and 491. So it is eligible in Victoria, South Australia, Tasmania, ACT and Queensland. Not in New South Wales, WA or Northern Territory, and the same applies for the 491 regional visa. South Australia might be an interesting one. I mean, you can still be nominated or sponsored in South Australia under the DAMA, and the DAMA does have a pathway to permanent residency, right? So that would have to be in Adelaide, right? So potentially that could be an option. Otherwise, I mean, you could potentially pivot and maybe study a web designer is now on the list. So on the CSOL, so you could upskill yourself and study something towards that trains you to become a web designer, and then that would also then make you eligible for 186 and the skill and demand visa because that's on the CSOL. So very unfortunate, but there still remains a few options. I mean, if you're going to stick with graphic designer, potentially a DAMA in Adelaide or 407 training visa if you have an employer that's prepared to nominate you for the temporary activity sponsorship program. Skilled migration, obviously 490, 189, or upskill yourself to become a web designer and that certainly is on the CSOL. So that would be my recommendation.
Thanks, Bill. We have another question from, I hope I'm pronouncing the name correctly, Zemena. I'm recently changing jobs. I've got 3 years of work experience as HR recruiter consultant that is in the core skills list, but I got a new job that is willing to sponsor me. Does it have to be with the same position?
Well, I mean, depending on depending on which visa she is going to be sponsored in, but I mean, for the skill in demand visa, she'd have to demonstrate, that she's got at least 1 year experience in whichever position she's going to be nominated for. For the 186 visa, if she's to be nominated, she'd have to have a positive skills assessment from BetAssess and be able to evidence 3 years skilled employment post her qualification, and this is a skill level 1 occupation, so she'd have to have a relevant bachelor degree. And I mean, it just depends. I mean, is Jimena with us today?
Yes, she is. I can unmute her.
So I just probably need to understand better,
Yep.
is the new position closely related to her 3 years experience with her previous employer? Is it in a totally different field? And that will also probably...
Yep. I've put I've enabled the mic. You can speak now.
Hi, can you hear me?
Yeah, yes, Jimena.
Thank
Yeah,
you.
just nice to chat to you. Thanks for your question. I just probably need some more information. Yeah, if you can just give me, well, is the new position related to HR, or is it something
No, the
totally
new
different?
position is unfortunately not related to HR. It's just as a project manager, and they are willing to sponsor under the 482
A project manager in which type of industry?
manufacturing.
And have you got any experience in that industry?
Nothing at all. I don't have anything on that.
And you have a bachelor degree in HR or something else?
I got the vet. I have no bachelor. I have certificate for advanced diploma and diploma in HR.
HR, okay. I mean, look, potentially, I mean, not necessarily as a project manager, but as a project coordinator. And we could potentially use your diploma in HR. And if you were able to accumulate 1 year work experience as a project coordinator or project manager, then you would fulfill the work experience requirement. I mean, the issue is, I mean, with the skill in demand visa or any sponsored visa, there's a work experience and education requirement, right? So you need to have a relevant qualification, right? So if I look at, for example, a program, or project coordinator or administrator, which has a specialization, project coordinator, right? Basically, the relevant qualification is it's a skill level 2. And the relevant qualification is an associate degree, advanced diploma or diploma, right? So the issue is that HR is not, I mean, probably not in the same discipline, but I mean, more or less, at least you do have at least a diploma. But the issue is either you have 3 years of relevant experience that substitutes the relevant formal qualification, or you have the relevant formal qualification plus 1 year work experience. And with the new skill in demand visa, you can't accumulate that work experience while your visa is processing. So it's a time of application criteria as well now, since the introduction of the skill in demand visa. So if you worked for your employer in that position for 1 year, then they could sponsor you.
Okay, cool. All right. Thank you so much.
You're welcome, Jimena.
Thank you. We just have one more question. So the employer needs to complete the financial amount. So I believe they're referring to the threshold, but yeah.
Yeah, so I mean, it could be a reference to caveats, financial requirements from the employer, or it could be a reference to the income threshold. I'll answer both. I mean, the minimum income threshold at the moment is 73,150. So the salary needs to be at least that. In saying that, it also needs to be at the Australian market salary rate. What do we mean by that? If there was an Australian citizen or permanent resident doing the same job in the same location, what would their salary be, right? So, if we're sponsoring engineers, for example, 73,150 is not the Australian market salary rate, right? It's at least 80,000, and I know that for a fact because to justify the Australian market salary rate, we often use the relevant award, which is the Professional Services Award, and we find a pay point for an engineer, and the pay point that we compare it to is 79,000, right? Now, other ways we can satisfy the Australian market salary rate is if there's an Australian or permanent resident employee in the same company doing the same job at the same skill level, then if we show their payslip and it equals the same as the nominated salary, then that requirement is satisfied. The third way we can demonstrate that is the Australian salary market rate is by providing remuneration surveys, whether it's pay scale, job outlook, or other remuneration surveys. And as long as those surveys indicate that salary is similar, then that's fine. On top of that, we also look at job portals, and we look at the same job title in the same city or location, similar location. And if we find 3-4 job advertisements for the same role and the salary is similar, then we can also justify the Australian market salary rate. Now, if this person was referring to potential caveats and the financial, depending on which occupation, but for a 186 direct entry visa, there is a financial capacity aspect that the employer needs to satisfy. And basically, they need to demonstrate through their financial reports that they are able to pay the nominated salary for at least the next 2 years, right? And that needs to be demonstrated via BAS statements, profit and loss, financial reports. Look, sometimes the business might not be making a profit, and that's still okay. But what we need to show is the annual sales of the business. And if there's been an upward trajectory, or for whatever reason, there might be some unusual costs like office relocation, or for whatever reason, the business has had some unforeseen expenses, and that could also impact profitability. But the matter of the fact is, in any of these cases, I mean, you can't bury your head in the sand. You need to articulate or explain in the submission why, for a particular reason, the business isn't profitable. However, the turnover or the sales is in an upward trajectory, and there's ways of also satisfying the financial capacity, even if the business isn't profitable, right? The other thing to note in terms of finances is that some occupations have a caveat. And for example, the business might need to have more than 5 employees. It might need to have a turnover of over 1 million. And the same caveats that apply for the skill in demand visa apply to the 186 visa. And if you look at this legislative instrument, it also says that this instrument is applicable to the 186 visa, right? So I hope that answers your question. Who asked that question?
This question was asked by Angelica. Yep.
Okay. I hope that answers your question, Angelica. All right. Any other questions, or that's it?
Just one request, I believe. So Clyde did ask, they're looking for an employer who's willing to sponsor them as a chef. So yeah, that's.
Oh, well, Clyde, I mean, yeah, I mean, just as recently as last week, one of our clients based out in Caloundra is looking for chefs, and we published an invitation, an expression of interest for budding chefs and cooks who would be interested to relocate to Caloundra on the Sunshine Coast. And we actually provided our employer client, with about 8-9 CVs. We had a lot more applications or expressions of interest. But yeah, from time to time, we do present these opportunities. So my advice to you and anyone else who's listening today, with us today, or the recording later, is follow us on our socials, so Facebook, Instagram, and also LinkedIn. We have got a plethora of business clients, and periodically they do ask us if we've got any clients who are relevant to their industry. And we do publish expression of interest invitations. And so you should follow us on social media and also sign up to our newsletter so you don't miss out in these opportunities. And I implore everyone to do so as well. So I think that's going to wrap it up for today. I'd like to thank